This is the scenario in question 3. The main character in this scenario are Mina and her boss, and we will discuss the issue provided in the scenario in the next one.
Good evening, everyone. My name is Song Jingfu, and my mention number is S65S09. Thank you for being here today, and I am excited to present our findings from the project conducted by Group 3 for MGM3273. And our research focuses on question 3 actually. And throughout this presentation, I will walk you through our key findings, analysis, and recommendation. So basically, based on question 3, we can see there has two questions. So the question A is about Mina's right under the Employment Act 1955, and the question B is about Mina's right under the Industry Relation Act 1967. So as a beginning, let's discuss about the question A first. So our issue for question A is whether Mina's boss has the right to terminate Mina without any reason. And the second question is whether Mina is entitled to claim her compensations if she believes her dismissal to be without just case or excuse.
Good morning to total. My name is Lee Jun and my mention number is S66408. Now I want to talking about the MENA rise under the Employment Act 1955. MENA sudden dismissal rise question about a rise under the Employment Act 1955. According to Section 12, Sub 1 of the Act, termination of employment requires notice in writing or payment in lieu of notice, which is dependent on the length of employment. As MENA has served for 8 years, she is entitled to 8-week notice period or equivalent payment in lieu of notice. The relevant case is the Wong Yun Hock v. Sharika Hong Leong Assurance STM BHD. The second principle is the Section 13, Sub 1 of the Employment Act 1955. Termination of employment contract is state that the employment contract can be terminated by either party provided due notice is given according to the contract or the Act. Additionally, Section 13, Sub 1 of the Act permits termination without notice only if indemnity is provided. Since Mina received no explanation or indemnity, her dismissal appears to violate this provision. The relevant case is the Gong Wei Poi v. JNP Cos MBHD. So the last principle is the Section 14 of the Employment Act 1955. Termination due to the misconduct. This section provides that an employer may dismiss an employee without notice if the employee has been guilty of misconduct inconsistent with the fulfillment of the express or implied condition of his service. However, due inquiry must be conducted before such dismissal. Since there have been no complaints or allegation of misconduct against Mina, this section does not apply to her situation. The relevant case is the Holiday Inn, Kuching v. Lee Chai Shok Elizabeth.
Alright, so look at the application for question A. Mentioned that Mina was dismissed without notice or reason after 8 years. And look at the legal provisions, Section 12, Sub 1 of the Employment Act 1955 requires an 8 weeks notice or payment in lieu because Mina has served about 8 years in the company. So refer to the case of Wong Yun Ho v. Sharika Hong Leong Insurance, Sharika Berhad, in 1995. So that is a good example actually. So besides that, we can consider that Mina's boss has been breached the contract because according to the Section 13 Sub 1, no notice or indemnity given. So this section mentioned that the employment contract can be terminated, but if the indemnity is provided. So the previous relevant case is Gok Win Ho v. JMP Court Ems Berhad in 1981. So the following section is section 14 should be applied in this case is because no inquiry was conducted in Mina's case before she terminated by her boss. We actually can refer to the case of Holiday Inn Kuching v. Lee Chai Shok Elizabeth in 1992. So according from these actions, we actually can consider that Mina's dismissal was in breach of the Employment Act 1955. She is entitled to 8 weeks notice or compensations and can file a complaint with the Labour Office.
Good morning to total Junaidah. My name is LIEW and my mandatory number is S66659. Now I'm going to talk about the conclusion for question 3A. Based on the provision of the Employment Act 1955, Mina's boss had no authority to dismiss her without a cause or any prior warning. According to Section 12.1 and 13.1 of the Employment Act 1955, Mina is entitled to an 8-week notice period or payment in lieu of notice. Since neither was provided, Mina can file a complaint with the nearest Labour Office to claim her entitlement. To seek redress for this unfair dismissal, Mina should take the following steps. 1 is file a complaint. 2 is the conciliation process. 3 is the Labour Court. In summary, Mina's dismissal without notice or just cause is a breach of her right under the Employment Act 1955, and she had clear evidence for seeking redress and compensation through the Labour Office and potentially to the Labour Court. That's all for me. Thank you.
Alright, so now look at the question 3B. So the question 3B was given about Mina's right under the Industrial Relation Act 1967. So the issue for question 3B is whether Mina are entitled to make claims for reinstatement if she believes her dismissal to be without just case or excuse. And the second issue is whether Mina has the right to deal with the trade dispute between employer and employee under Industrial Relation Act 1967.
Good morning to doctor. My name is Lee Kuni and my number matrix is S66819. 19. So for today, I would like to present about the principle for question 3b. So for these questions, the principle that use are section 20 and section 30. So for section 20 of the Industrial Relations Act 1967 is about the unfair dismissals, which is applicable to dismissal for poor performance, breach statement, or resignations or constructive dismissals. So for these sections, the employee can file a claim within 60 days at Industrial Relations Department. If the conciliations are failed, they can go to the industrial court, claim for reinstatement or compensations in lieu. So for section 20, it also divides into a few subsections, which is subsection 1, subsection 2, subsection 3, subsection 4, and subsection 5. So for section 20, subsection 1, this section is that if a workman has been dismissed without just cause or excuse by his employer, he may make representations in writing to the Director General to be reinstated in his former employment. So for section 20, sub 2, the Director General shall within 90 days send to the following parties representations of the following matters. The Director General shall take such steps as he may consider necessary or expedient, so that the expeditious settlement thereof is arrived at. Where the Director General is satisfied that those representations are unlikely to be settled, he shall inform the Minister thereof. So for section 20 sub 3, when the Minister receives the notifications from the Director General under subsection 2, the Minister may, if they deem it appropriate, submit the representations to the court for proceedings to be made to an award. So for section 20 sub 4, if an award has been made under subsection 3, this award shall amount to the bearing of any action pursued by the workman in a court of law for damage that were caused by wrongful dismissal. So for the section 20 sub 5, this section shall not apply the dismissal of a workman in a circumstance arising out of a contravention of section 59, where proceedings have been committed before a court in respect of an offence under section 59 sub 1. The relevant case for section 20 are Dreamland Corporation M. Sandira Berhad v. Chong Chin Soy and Anot, and also the Fong Kyong Rubber Manufacturing M. Sandira Berhad v. Lee and Kia. So for another principle is section 30 sub 5 of the Industrial Relations Act 1967 is about the right to be heard. This section is require the industrial court to act according to equity, good conscience, and the substantial merit of equitable principle, which necessarily include the basic rules of natural justice must be observed. So for this section 30 sub 5, the relevant case is Malaysian Airline System Berhad v. 1 Saadi Sheikh Saadi Adi bin 1 Mustafa.
Alright, so now look at the application for question 3b. So it actually mentions that Mina was dismissed without reason. This is the case fact. So look at the legal provisions under the Industrial Relations Act 1967. Section 20 sub 1 allow Mina to request reinstatement within 60 days at Industrial Relations Departments. So if after 60 days, the power will lose its function. So Mina should go within these days. The section 20 sub 2 to sub 4 is the procedure should be followed by Mina. So Mina should try to protect her right against her boss' unfair actions. So we actually can refer to the cases of Junaidah Corporation, Syarikat Berhad v. Chong Ching Sui and Fang Kyong Rubber Manufacturing, Syarikat Berhad v. Lee and Kiet. So actually these are the good example under this section. So after we discussing all the relevant principles, we suggest that Mina should be tried to file a claim for reinstatement or compensation. So the process involves conciliations through the Industrial Relations Department and potentially the industry.
Good morning, doctor. My name is Eric Hong and my metric number is S68012. The last is conclusion. So based on the principle and the application of the relevant section of the Industrial Related Act 1967, Mina has a strong ground to challenge her dismissal as being without just cause and excuse. She should promptly file her representation with the Director General of Industry Relations to seek reinstatement. If conciliation failed, she has the right to have her case referenced to the industry court, where the court will examine whether she dismissal was justified and whether due process was followed. Give her clear work record and the lack of the reason for her dismissal, she have a substantial case of unfair dismissal. So that's all for me. Thank you.